So welcome everyone to the National Popular Assembly free online law class for Sunday, October 25th, 2020. And tonight we're going to continue our discussion about grand juries. The documents that you can download for this class are in Class 6, Docs and Links, on the Vocational Science of Freedom Gilded server, the link of which is available on the VSOF YouTube page. So tonight we're going to start off with a document titled How to Save the Republic, and in it it's instructions to create a common law grand jury. Now, of course, this is someone's writings, not of a judge or some sort of authority, even though technically they cannot, under any circumstances, give us any direction as to what we should do or how we should go about doing it when it comes to the grand jury, because the grand jury, being the fourth branch of government, is above government. And when the grand jury is convened, as long as you have 25 people specifically, as it says here, how constituted grand jury members must be elected by the people, not citizens of the jurisdiction, meaning the county in which they are operating. So in order to do a proper common law grand jury of 25 members of the peerage, you do have to be a member of the peerage. And that gets into the presumptions that they have against us, that we're all infants in the definition of Title I, subsection 8 in U.S. Code. Under the definition of person, you'll notice that a person is an infant. And infants, of course, have no rights to do anything. However, the people do. So, which is why everyone who gets their doc set done will remove that presumption of infancy and a lot of other presumptions that go along with what they're doing to us. But we'll leave that for a later time. Just to say for now that you have to be one of the people, and you have to know that you're one of the people, and you have to know that you have the right to do this and why. So to start reading out of this, the grand jury members must be elected by the people, not citizens, of the jurisdiction, county in which they are operating. There are no rules defining a procedure for how they are elected. The people, without the influence of government, must decide for themselves how the grand jury members are elected. There must be at least 25 members. Qualifications. The members must be people of the jurisdiction and not citizens of the jurisdiction. For example, they must be people of the state of New York, not citizens of the state of New York, and certainly not citizens of the United States. Each member must be shown in and promise to observe all of these rules, and so far as within his power, cause the rules to be observed. And they have an example here under the New York State Constitution for the oath of office. Now, this is not the oath that you would take as a grand jury member. This is an oath that you would take to be a public servant. And the oath that you take as a grand jury member is substantially different than this oath. So whoever wrote this didn't realize that this is not the oath that you would take to be a grand jury member. The grand jury has its own oath. I could paraphrase it, but I'll make sure that I place it into chat later on tonight, maybe even after the class. If someone would please remind me to do that. That I've made sure that I put correctly into the grand jury manual. And it's substantially different than this particular oath that deals with being a public servant. But to continue. So, election procedure. We must do everything open and in public. Once you have the 25 people, you can choose a jury foreman and a secretary. You could also choose a treasurer as well. Most counties have funds set aside for grand juries, of which you can access. Also, the other thing that the grand jury would want to do is to have copies or have availability of being able to look over the notes, minutes, and procedures of the previous grand juries in a county. So once you have these things done, the grand jury secretary is to call the town hall in your county seat, identify themselves as the grand jury secretary, and secure the hall for a meeting and an election for a new county grand jury. Now, you can meet and have a grand jury wherever you want to. You can have 25 people meet out in the woods if you feel like it. Entirely up to you. You can meet in a barn. You can meet in somebody's house. It doesn't matter where you meet. That's irrelevant, because even the Magna Carta says that the grand jury can meet in secret. So they can meet wherever they bloody well want to. So, yes, you can do it in the town hall, but you can also do it wherever it is appropriate that you feel you can get the job done. I would suggest having a place where you have a whiteboard up front, a place where you can have a podium, a place where you definitely have audio-video recording, and a place where everybody feels comfortable being able to write up notes and do paperwork and the like. You want to post the date and time of the election on the bulletin board where you're going to do this, and in the city and the county and the local newspapers. That's something that we can get into later, but I have some templates for that, but I'm searching for other templates to kind of merge them so we can have one simple template that any county can use in any state that will be able to go ahead and filed place into the newspaper to ask people to come forward for the grand jury and why. So the quorum, when the grand jury meets, if there are any absent after being summoned, then those present constitute a quorum. That's to a point. I would make restrictions on that if I were being the foreman. You don't want to end up having 12 when you actually have 25 that should be there. But nonetheless, who would be there if there is a few missing, that constitutes quorum. If any member dies or leaves the county or in any other way is prevented from carrying out the grand jury's decisions, the remaining grand jurors shall choose another to fill his or her place, and he shall likewise be sworn in. That makes perfect sense, because you want to have a contingency plan for anyone who may leave or in this unfortunate case were to die. Finality of decisions. No decision of a grand jury is reviewable in any court of the government. That's true. However, the grand jury is usually just a accusatory body. There are some situations of which a grand jury can actually perform a trial, if you will. One of them is on what's called a writ of attaint. So in a writ of attaint, which is something that was actually used in the colonial days, it's not used much anymore, but the fact that it does have precedence in American jurisprudence means that we can use it now if we wish to. And the writ of attaint is used when someone has been put through a trial, say a criminal trial of something. So say someone ends up on a criminal trial or something of, say, something like a traffic ticket or something, or a DUI or something like that. That individual, that person, that people could bring a writ of attaint to the grand jury and have the entire case retried in front of the full grand jury. And basically then all they would need to find, if you had an intelligent grand jury, is you could just simply say, hey, there was no evidence ever proving that I was engaged in commerce on the roads and highways, and that I was not using the roadways as a place of business, and the grand jury could then vote and basically dismiss the case. That's a writ of attaint. So there are some situations of which a grand jury can actually hold a trial. But there are no specific rules for the grand jury as to what or how they're supposed to operate, and so on and so forth. It's just been tradition, for the most part, through American jurisprudence, that they are an accusatory body. So they just accuse, and then the accused has an indictment brought or written up by the grand jury to say, yes, we feel that they should be tried by a petite jury, a jury of 12 members of the peerage, for whatever particular charge they may find enough evidence to show that there should be some sort of trial for. And then it gets passed on to the petite jury and a prosecutor. Now, as far as the prosecutor is concerned, there's all kinds of interesting things about district attorneys and county attorneys and whatnot. Even to take an interesting example of this, in Iowa, they technically legislated out the office of district attorney like decades ago. in Iowa, but yet they're still sitting there. Why? Well, it's because no one's bringing a grand jury indictment saying, what are you guys still doing here? Right? The way that we clean up our county and the way that you keep a republic is through a grand jury. The highest power is in the people. It always has been. And you can see that also in the 9th and 10th Amendments of the federal Constitution. Basically, all power is not delegated, yada, 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 right? Or to the people, are withheld to the people or the states, right? So, and I was paraphrasing that, by the way. I just butchered the 9th and 10th Amendment, so make sure you go look it up, because that wasn't exactly what it says. But the point is that all the power not delegated to the state or federal courts is withheld with us. And the fact that just because we delegated a power doesn't mean that we can't choose to then turn around and wield that power on our own whenever we see fit to do so. Because power is always vested. So power is always vested from us, and it can be, of course, divested. Which means that if you wish to hold your own court of record, so you convene your own court of record and you say, hi, I'm now going to convene a court of record. It's going to proceed according to the course of the common law. It's going to have all the 5 different aspects of what a court of record is, and it's not going to be an inferior nisi prius court, not of record, that follows Roman civil law. Instead, it's going to be a court which proceeds according to the course of the common law. That would be you then wielding your own power from your own volition, just simply because you wish to. And you can do that because if you delegated power to the governments to create courts, of course you can create your own bloody court. That's exactly what everybody should be doing when the corporate state comes up against you. You should file in a court of record, and in most states, honestly, you'll find the term court of record. You'll find it in either the statutes, or you'll find it in a lot of different places. Sometimes you'll find it in the government codes of certain states. Sometimes you'll find it right in the Constitution of certain states, as California. I believe California's Constitution states that all courts in California are courts of record. Now, just because they state they're courts of record doesn't mean that they're operating like courts of record. So if you're in a court that's not operating as a court of record, are you in a court of record? Answer is no. So if you want to operate in a court of record, you have to make sure that you understand what a court of record is and how a court of record operates. Because if you don't know the rules, how are you going to enforce them? And so in order to do that, you need to understand the rules of how a court of record proceeds according to the course of the common law, compared to how an inferior court not of record proceeds according to Roman civil law or statutes, acts, ordinances, and codes, or what most states go by is their state rules of civil procedure. Well, civil law means Roman civil law. And if you want to understand the fact that it is a foreign system of law, and that Roman civil law has always been foreign to us, all you have to do is read the cover, literally just the cover, meaning the actual name of Bouvier's Law Dictionary, and you'll get the point. Because it'll say in Bouvier's Law Dictionary, on the very cover, it'll say, with references to civil and other forms of foreign law. So Roman civil law is foreign to us. It always has been. And the only reason that you get yourself wound up in it is through contract. So anyway, to continue here. So jurisdiction, any government transgression, any government transgression against anyone in any respect, any government breaking of articles of peace or security, any dispute regarding anyone who has been deceased, unconstitutionally detained, or removed by the government without legal sentence from his peers, from his lands, castles, liberties, or lawful right. Any of these things are something that you can bring into a court of record, so that to fix. And it's also something that you can also bring to the grand jury to investigate into. And as I said, the grand juries can meet wherever they want to. They don't have to meet in the corporate for-profit courtrooms that they've created. Excuse me. You can hold a grand jury wherever you want to, and the aspects of what we can do with a grand jury as a little list here in this How to Save the Republic document. They have some things of what can be done, what's possible. We can turn back the political clock to 1798. We can turn back the judicial clock to 1798. We can indict criminals, including judges and politicians. We can reinstate the real duties of the sheriff. We can reinstate the elected committeemen. We can get our armories back. We can get our militia back. We can force compliance to the Third Continental Congress, Articles of Freedom. That was something that was done in 2009. I won't get into it, but that was a very interesting event that took place. We can stop Agenda 21. We can ban GMOs. We can ban high fructose corn syrup. And the ways that you can do this, the ways that you could completely ban GMOs, is that you simply pull the charter of the corporation that's creating them. Yes, you can do that. You want to end Monsanto? Pull its charter. Prove that it's causing damage, harm, loss, and injury, and a corporation's done. A corporation has absolutely no capacity whatsoever to do damage, harm, loss, and injury. And most people will end up trying to sue the corporation for monetary damages. Well, that doesn't stop the harm. You want to stop the harm, pull their charter. Okay. Anyway, these things go on and on. We can end gun control. We can force the courts to return to common law. We can delete the IRS, so on and so forth, right? And yes, these are all things that can be done, as long as people know what they're doing and they're organized properly and know how to do it. So it gets into procedure here. Dispute settlement. If the grand jury is informed of any dispute regarding anyone who has been deceased, unconstitutionally detained, or removed by the government without legal sentence of his peers from his lands, castles, liberties, or lawful right, then the dispute shall be settled by the grand jury. Yes, they can settle it if they wish to, but it would be more appropriate to simply have the grand jury write up an indictment and then hire, determine, elect, whatever you want to do, a special prosecutor to prosecute for the grand jury, and that person should know what they're doing and understand how to run a court of record. So that would be the proper way to go about it. I wouldn't go running and try to run a full trial of anything through a grand jury right off the bat, particularly if people were just getting settled in as to how to do this and getting organized. That can come at a later date if you need to. Procedure 2, enforcement. 4 of the members must be shown that because of government, A, a transgression has occurred against anyone in any respect, or B, that some of the articles of peace or security has been broken. The 4 members must show to the government, or the government must show to the government's error. The 4 members must, by the way, where these 4 come from, it goes all the way back to the Magna Carta. So if you look up the Magna Carta, and the things involving grand juries are towards the end of the Magna Carta in I believe it's Articles 64 and 65, or it might be 63 as well. But anyway, just go look it up and read it. And you'll see that it states that when the 4 barons, it talks in the Magna Carta of the 4 barons, can have an issue with the king, the 4 barons are to go to the king and to show him the error of his ways. Right, which is what it says here, like number 4. If the government does not amend the error within 40 days after being shown the error, then the 4 members shall refer the matter to the remainder of the grand jury. That's basically right out of the Magna Carta, that number 4 here, that's spoken of in How to Save the Republic. So basically what happens, and this is something I probably should have prefaced before, but when the grand jury would meet when this is going back to the powers and the aspect of the Magna Carta, when the grand jury would meet, they would literally take over government, meaning the king was technically no longer governing, the grand jury was governing. And the 4 members were called the 4 barons, and they were basically the investigators of the grand jury. So there were people not all that long ago that had come to me and said, well, hey, we made badges and stuff for the grand jury members. I said, that's great. I said, did you make 4 for the investigators? And they're like, for the investigators? I said, yeah. I said, in the Magna Carta, it specifically states that there can be four investigators. And if you have 4 investigative badges, you say you're investigators of the grand jury, you can pretty much walk into wherever you bloody well want to. And if anybody stops you, you simply say, what's your name? And then you make sure that there's someone with a subpoena to come before the full grand jury and explain why they got in the way of the 4 investigators. That's how you take care of that problem, if anybody wants to get snarky with you. So anyway, the 4 would go to the king, and they'd say, hey, king, you got a problem here. We have a problem here. You imprisoned so and so forth without a trial or whatever, blah, blah, blah. And, he has a right to a trial and so on and so forth. And if the king would say, too bad, I don't care, then they'd go back to the grand jury, the full grand jury. And what they could do is that they could, I believe what it says in the Magna Carta is, repress the king and take all his stuff. They can't harm the king or his family, but they can basically put him into destitute and take everything from him if they feel to do so. So that was in a very short synopsis. There'll be a class that I'll cover the entire Magna Carta at some point and go all over this in complete detail. But for the time being, the aspect of what the 4 grand jury members are, as far as the investigators are, that's what their job was. It was to take the errors of the ways of the king to the king and say, hey, you got 40 days to fix this. So in our scenario, what would that be? It'd be, you'd go to the district attorney and say, hey, it appears as though you arrested and throw somebody in jail for traveling down the roadways. Did you have any proof that he was engaged in commerce? And if the district attorney says right there, no, then the grand jury can order him to dismiss all charges and to release he or she who was imprisoned, because they're not following the law. So anyway, to continue, number 5, the grand jury may distrain and oppress the government in every way in their powers, namely by taking their homes, lands, possessions, and any way else that they can, until amends have been made according to the sole judgment of the grand jury. That's more along the lines of how it's written in the Magna Carta. So this has modern vernacular in it here, but the way that sentence was structured, number 5, is more or less how it reads out in the Magna Carta. And of course, limitation of powers. The grand jury may not imprison or execute any government personnel or their children. That's basically what it said in the Magna Carta. Same idea. You can't do anything personally to the king or the children or family, whatnot. And then public support here. Anyone, people, or citizen who chooses to help enforce the grand jury decision must first swear that he will obey the mandates of the grand jury, and that with them, to the extent of his power, will impose the grand jury's decision upon the government. That can be basically the militia. People will always ask me, well, how do you enforce any of this? Well, you enforce it by the Second Amendment. You enforce it by appointing marshals to your own grand jury in the counties. You enforce it by summoning and mustering your county militia and saying, look, we got to go take care of something. That's it. You take care of it. You don't sit there in negotiation. You don't whine about it. You go take care of it. Because we, the people, are the only ones that can. And it's because we haven't. It's because you find yourself in this Luciferian scumbag communist regime of a federal corporation who has systematically stolen everything from you since after the times of Reconstruction, after the Civil War. So we're the only ones that are going to fix this. So you don't go crying to them to please stop oppressing you when they're well aware of what they're doing and they have no intention of stopping. And just as a side note, first time offense under common law for thievery is death. You hang a thief. So keep that in mind. Treason comes along with the death penalty as well. So, limitations on government. The government is prohibited from doing anything or diminish the effect of the grand jury. That's absolutely true. There's nothing I can do about it. 2, if the government does prohibit or diminish the effectiveness of the grand jury, it shall be vain and invalid and may not be used in any later proceeding by government or anyone else. Also true. It's basically, it doesn't have any effect at all. No force or effect. Termination of enforcement. When all issues are settled to the satisfaction of the grand jury, things shall return to normal as they were before. No grudges. Okay, fine. Reactivating the common law grand jury, a brief strategy suggestion. Like, again, these are all suggestions because, of course, you can do this however you feel you bloody well need to. But anyway, a little background here. When the colony separated from England, that should say King George, not King John. King George retaliated by revoking the charters. Technically, the colonies were without legal authority to operate. However, civics, the branch of political philosophy concerned with individual rights, was generally taught and known by the people who asserted their rights and maintained order by applying the common law. The people united in the form of common law grand juries and continued the functioning of the government. For as I said, when the grand jury is in effect, technically they are the government. As the legislatures matured, they slowly increased governmental power while simultaneously reducing personal sovereign power. There's a lot of ways that happened, and it pretty much was a slow boiling the frog process over the last 250 years, but I won't get into all the rest of it. This was done through a culmination of passing pro-government legislation and reducing or eliminating education about civics, which is of course what we teach here today, and two quarter centuries later, hardly anyone even knows the meaning of the word civics, which is a good point. Despite the fact that the state and federal constitutions still acknowledge the common law as the ultimate law system, people everywhere are conditioned to believe that the statutory law and codes are the only source of law. That's Roman civil law. And the only remaining common law term generally known among the public is common law marriage. The common law grand jury is now dormant because of the public ignorance of its powers and supersedes all other government entities, including the modern statutory defined grand jury. Now, well, all right, I'll finish. Awakening the grand jury will be graciously accepted by the government. A strategy is needed to reintroduce this fundamental protection against tyranny and injustice. Yeah, they're kind of waiting for us to stop being infants. The only thing that they're doing, actually everything that they're doing on the federal side, because as I say, once you go and read Title I, United States Code, subsection 8, under the definition of person, you'll see that all acts of Congress are only dealing with persons, meaning infants. They're just administering abandoned estates that got dropped off at the foundling hospital by document. Of course, the parents do take the child home, but they abandon their child by document at the foundling hospital. And a foundling is a child of lost or unknown child of unknown parentage. So a lost or abandoned child of unknown parentage is what is the definition of a foundling. And all the hospitals out here are foundling hospitals. Okay, they're also all military hospitals after the Civil War, which is something else that a lot of people don't know. So what do you have? You have, under the Lieber Code, which is Executive Order 100 from Lincoln, you have the military supposedly protecting the Republic. So you have all of these babies being born in the Republic that then turn around and get abandoned, and the state, the corporate state, turns around and administers them for the rest of your life by a special administrator. And all the judges, all the black-robed priests of L sitting up there, they're all special administrators. There was one time that we filed something in, I believe it was Chicago. Yeah, it was federal court in Illinois somewhere. And no, it wasn't federal, state court in Illinois. And it was basically a motion to show cause to adhere to judicial canon or abjure the realm. What we basically said in the motion, and this motion was to the court, it was not to the other party. The court had to answer this motion, and they defaulted on it, and then we defaulted them, and then they said, okay, fine, this is what we said. You have to, if you're going to be a judge, not a special administrator, if you're going to be a judge, then you're going to be bound by judicial canon. Judicial canon states that you must see evidence and rule accordingly. Not sit there and mess around with filthy attorney work product doctrine where everything gets shuffled off of the court file and there is no evidence on the court file. right? Or allowing the judge to be a quote unquote trier of fact to determine what is or what is not a fact. No, that's not within the aspects of judicial canon. What if they're going to be a judge? They have to be a judge. They don't get to be a special administrator. So this is what we said to them in the motion, and basically the judge turned around and signed off on it, and he said, "I'm not a judge. I'm not bound by that. I can't be bound by that. I'm only here as a special administrator, and I'm not a judge." And we were like, "Okay, great, thanks. Now we know where we're at. Now we know where everybody's hanging out at," which was an interesting admission because it told us that we were exactly on the right path and we knew what they were doing. The other thing that they're doing too is they're running everything through probate. Now there was a probate manual that we pulled out of, I believe it was Georgia, where they said specifically in the probate manual that they were running traffic court through probate. Well, why would they do that? Well, because that's where they make their most money for their 501c3 slush funds, which is what every single judge has. The judge's retirement fund is a 501c3 non-for-profit religious corporation. Now, if you want to see the books of those corporations, convene a grand jury. Order every single judge in every single county to produce every single scrap of paper and every single bit of worthless Federal Reserve note money, shekels, that has gone through that 501c3 slush fund, and demand that he show cause as to how he attained it and what they're actually doing. And you will be stunned of what you find, which I won't get into now. I'll just leave that as something that we can all do at a later time because it's going to be important. All right, to continue here. Step 1, establish legitimacy. The first step is to get public acceptance. Every dictator in history understood the power of the people and cultivated their support either through enticements or threats. Reactivating the grand jury concept may go through 4 traditional stages: denial, ridicule, violent oppression, and then self-evident acceptance. The executing of 62 juries, 1 for each county, is likely to reduce or eliminate the stages. Now, I don't know what state they were talking about. Some state that obviously has 62 counties. There are 3,400 and some, or maybe 3,500 some odd counties in America, if you count them all up. And each one of them should have its own functioning grand jury. So anyway, the grand jury foreman shall apply to, it was New York, all right, fine. The grand jury foreman shall apply to New York State Supreme Court administrator in their county for use of one of the courtrooms in the public courthouse. That is entirely up to you if you want to do that. I tend to be a little bit more Sun Tzu because I'm a Taoist. I don't want them to know what I'm doing, honestly. Nor do I care. It's none of their business anyway. If they want to know what we're doing, they'll figure it out when they get subpoenaed. I don't give a damn about going to the state court administrator. Now the grand jury as a whole, if they wanted to, could do this, because the grand jury should have their entire dock set done, meaning they are 25 people that are out. You've claimed your estate, you've come of full age, you've been found to be living as per a proper judicial coroner proof of life and proof of age inquest. You've corrected the probate record and you've appointed all them as trustees of your estate. Then if 25 people have done that, you can all protect each other, because if they come against one of you, you can indict any one of them that comes against any one of you for unlawful administration of your estate, basically probate fraud, immediately. And not only that, you can put them under a $300 million binding arbitration suit, which several students have already done, and one of them has won an award against judges in Colorado, and has an award against them, and actually has put that award into the county recorder's office, the county land records office, and now has a lien against that judge's house. But that's a story for another day. to get the 25 out and then to get them organized, you can protect yourselves. So no more of this bullshit about, well, how are we going to do enforcement? Protect yourselves. That's what the grand jury is there for anyway. It's for us to govern properly without any fear of repercussions or what they may say, because there is no authority that they could bring that would alter or be able to tell you as a grand jury how to go about your business. And that was actually specifically stated in the Williams case, USA versus Williams, where I forget what justice said it, but basically they said, we've been asked many times to write up procedure and policy for the grand jury, and we not only will we not do it, we can't do it because they're above us. So that's the Supreme Court talking. So if you have any question about that, you can just go read USA versus Williams. It's got a lot of good holdings in that case. So anyway, so to continue here, the grand jury foreman shall, okay, so we've read that. If it is refused, a writ of mandamus shall be petitioned to the district federal court to command obedience to the grand jury. Then the court administrator should, under common law procedures, be sued for his dereliction of duty. Now, you can go through all that if you want to, but honestly, I don't see the point. But if you want to, if you want to force the Roman civil law corporate government to go along with it, you can start your fight there, I suppose, if you want to, but that's entirely up to, your own grand jury. The grand jury should follow normal procedure. In other words, if the grand jury begins a process on its own, the resulting accusation is called a presentment. If a prosecutor originates a process, then the jury returns to the prosecutor an indictment. Now, here's the thing. Anyone can come to the grand jury and say, hey, I'm going to initiate process against this guy. This is what I'm bringing. And then the jury can turn around and give them an indictment. And it doesn't have to be the district attorney. In fact, all cases in common law in England regarding torts or damages were all prosecuted by the one who was harmed. There was no centralized prosecutor for the king. I mean, I suppose in a weird way you could consider the chancellor in some respects in that nature a prosecutor, but really only from a standpoint of things dealing with the crown or maritime admiralty issues. Everything else was done privately. So you prosecuted your own case. So anyway, so with that, so they'll bring an indictment, and also it's also called a true bill. So on acceptance, or a no bill on a denial, so they say, nope, we don't see that there's enough evidence here. We'll no bill it. So it says, note, be careful with your words. Wrong words may result in an action. If you call the presentment an indictment, the prosecutor may feel no obligation because he did not initiate the process. Yeah, this just goes to know your vocabulary. Just understand what you're doing. So to continue, gain public acceptance, the grand jury should have a strong public relations program for this step. And I agree. And there should be a report. You should do a report, a grand jury. I covered a grand jury report in a previous grand jury class. I'm not sure it was last week. It might have been the week before that. Anyway, it'll be posted up on YouTube shortly. I'm going to get done with it tonight and post it. And you can see what a grand jury report looks like. Also, a grand jury there's some really good instructions for a grand jury as far as doing a press release on 1215.org. Bill Thornton has put together some really good documents as far as how you would want to go ahead and do a press release about telling the public as to what you're up to and so on and so forth, and telling everybody else what you're up to for that matter. That you can post in the newspaper and post around town and wherever else you want to post it. Yeah, I think Bill Thornton's still, he's still alive as far as I know. At least his site gets updated every once in a while. So to continue here with the documentation, the United States versus Williams, this is a Supreme Court ruling, which I covered last time. So in a 6-3 decision, Justice Anton Scalia, writing for the majority, confirmed that the American grand jury, is neither a part of the judicial, executive, nor legislative branches of government, but instead belongs to the people. It is, in effect, a fourth branch of government, governed and administered directly by and on behalf of the American people, and its authority emanates from the Bill of Rights. The following are extracts from the Supreme Court's 1992 decision, which is when United States v. Williams was passed. The grand jury is a constitutional fixture in its own right. The Fifth Amendment demands a traditional, functional, common law grand jury. The grand jury is an institution separate from the courts. The courts do not preside over the functioning of the grand jury. The courts have no supervisory judicial authority over the common law grand jury. The grand jury belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. The grand jury's functional independence from the judicial branch is evident both in the scope of its power to investigate criminal wrongdoings and in the manner in which that power is exercised. The grand jury can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. Meaning, they don't have to have any reason. The four investigators of the grand jury can go down and just start walking around and say, hey, what are you guys doing here? Just because they want to make sure and have assurances that everything's running smoothly. They do not need a reason at all, which I covered when we talked about Hale versus Hinkle, when a corporate officer thought that the grand jury needed an indictment before they could subpoena the records. Well, that did not go so well for him. But anyway, I covered that in the previous class. So to continue, the grand jury need not identify the offender it suspects or even the precise nature of the offense it's investigating. The grand jury requires no authorization from its constituting court to initiate an investigation or to seek an indictment. The grand jury operates without the interference of a presiding judge. The grand jury swears in its own witness and deliberates in total secrecy. The grand jury remain free to pursue its investigations unhindered by external influence or supervision so long as it does not trench upon the legitimate rights of any witness called before it. Now, there's some interesting aspects of how limited their rights are when you actually read Hale versus Hinkle, but that deals with corporations. So the Fifth Amendment's constitutional guarantee purports an investigative body acting independently of either prosecuting attorney or judge. Double jeopardy clause of the Fifth Amendment does not bar a grand jury from returning an indictment when a prior grand jury has refused to do so. The Sixth Amendment right to counsel does not attach when an individual is summoned to appear before a grand jury, even if he is the subject of the investigation. It would run counter to the whole history of the grand jury institution to permit an indictment to be challenged on the ground that there was incompetent or inadequate evidence before the grand jury. So these are some of the things that that are laid out as to what was actually stated in USA versus Williams as to what the Supreme Court has literally stated. So it's a very good list for people that are going to be potential grand jury members to read and to understand. In summary, the common law grand jury is an unalienable right of the people, a fourth branch of government created and administered directly by and on behalf of the people. It is separate from the courts, functioning by its quote, own will, close quote, above the government, serving as a referee between the government and the people. It is an investigative body acting independently with unhindered power to investigate and indict criminal wrongdoing merely on suspicion that the law would be violated, or even because it wants assurance that it is not, and needs not identify the offender it suspects or even the precise nature of the offense it is investigating. It swears in its own witnesses, deliberates in total secrecy, and its indictments cannot be challenged. In short, it has a duty to seek, not seeks. In short, it has a duty to seek out injustice and rectify it. And so the rest of this is some law notes. This is from the Magna Carta. This is from the Confirmaro Cartarum. This is the confirming charter that each king, after King John has signed, that confirmed that the Magna Carta was the common law of England. And this is an interesting read. I'm not going to read all of it. It's I don't think this is the totality of it either. I think it has more than 6 sections, but I could be wrong. or 6 articles probably. And then the rest of this document gets into the sovereignty of the people, why we're sovereign. I'm not going to read all this. You guys can read this. This can be your homework assignment to read the rest of this at your leisure. Reservation of sovereignty. This is an interesting case dealing with Jicarilla Apache tribe versus Marion et al. Or sorry, reverse that. Marion et al. Versus Jicarilla Apache tribe. This is a court case that I know that Bill Thornton brought to the attention of everyone, because I know this is on his tapes. And what this case was about, I'm just going to end with this case and then we'll stop for the evening. Basically what this case was about was that there was a corporation that went on to the Apache tribe's land, and they did a contract to do so, of course, with them. And so they signed a contract to go in and mine minerals off the Apache's land. And tribal council got together and said, we should create an extraction tax for taking, minerals off our land and whatnot. And so they created the extraction tax, and then they started to apply it to the corporation. Corporation screamed to high hell, and they said, this isn't in the contract, and they took it, and they got all the way to the Supreme Court. The Supreme Court said, tough shit. They're sovereign, they can tax. And this is what they said. Even if the tribe's power to tax were derived solely from its power to exclude non-Indians from the reservation, the tribe has the authority to impose the severance tax. It has the authority to impose the severance tax. Non-Indians who lawfully enter tribal lands remain subject to a tribe's power to exclude them, which power includes the lesser power to tax or place other conditions on the non-Indians' conduct or continued presence on the reservation. The tribe's role as commercial partner with its petitioners should not be confused with its role as a sovereign. It is one thing to find that the tribe has agreed to sell the right and use the land to take valuable minerals from it, and quite another to find that the tribe has abandoned its sovereign powers simply because it has not expressly reserved them through a contract. To presume that a sovereign forever waives the right to exercise one of its powers unless it expressly reserves the right to exercise that power in a commercial agreement turns the concept of sovereignty on its head. What are they saying? They're saying once a sovereign, always a sovereign. What are they also saying? They're saying it doesn't matter all these contracts that you have with the corporate state. People that always come to me and say, oh, you have a social security number, that means you're not sovereign. Really? Supreme Court would tend to disagree with you. Okay? Now, not to say you shouldn't remove yourself from those contracts. That's not what I'm saying. What I'm saying is that once you're sovereign, you're always sovereign. And this is what this case specifically refers to. So anyway, coming up on an hour, so I'll leave it there for now. You guys can read the rest of this. I'll get to the other two documents, the primer on the grand jury by Richard Walbaum, and the federal grand jury is the fourth branch of government when we convene next week on Sunday. And for everybody's knowledge, the Sunday law classes are free. You can join them at the Vocational Science of Freedom Gilded server, and the link to the Gilded server is in the upper right hand corner of the Vocational Science of Freedom YouTube channel banner, if you need to find it that way. And you can find the docs for tonight's class in class 6 under National Popular Assembly classes. So you just go to National Popular Assembly in the Gilded server and come down to class 6, and you can click on the Dropbox link, and that will take you to all of the documents that we have been covering for the grand jury and onward. So that'll conclude it for tonight, and I will turn off the recording and we can continue with our meeting and talk amongst ourselves.